As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them.
We have to check back in with the civil case going on with Karen Reed, because there have been 3 discovery hearings. We are going to go through in time order of the discovery stuff that's going on this month. This is the day in and day out boring law that in this case is of course not boring, because what would be normal? The ins and outs of civil litigation that we don't often see, we are going to take a peek because we learned some new things. I was trying to prep this and pulling up motions that were filed yesterday in some of the criminal cases we've been tracking, like the Miles King case, because those cases are still ongoing where they're fighting over Proctor's phone. And then remember, it was in those cases where we learned that Proctor had rehomed his phone and gotten a new phone and told everyone, like, oh, you're not going to get much from the phone. And then they got the entire iCloud and like tens of thousands of things and like emails and text all the way back to like whenever. Remember that? Right. So those are still going on. But also there's a whole civil case going on. And where the two meet in the middle today is going to be wild.
We followed up with a second subpoena to Mr. Proctor approximately September of 2025.
Would you agree that 8 months to resolve issues from subpoenas might be a little unreasonable?
Yes. Yes, Your Honor. Yes.
I certainly would, Your Honor.
Yes.
But here's what's been happening in this case. Every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena,
Shocking.
as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department. Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now.
Right.
And it takes time to even get people on the phone. We get them on the phone. There's continued refusal to produce documents. We attempt to confer as we're required to under 9C to try and get documents without burdening the.
Excuse me, Your Honor. They're just fucking with us. Here is the circle of fuckery that we are dealing with. We send a subpoena, it's ignored. Then we follow up and they want to confer. Then we've got to get whoever their counsel is or outside counsel or whoever on the phone. And then we confer and then they object. And then we try to deal with the objections and then they object again. And around and around and around and around.
Court with motions to compel. We then, in some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified.
Tell me more about Proctor's cell phone. Tell me everything about Proctor's cell phone.
Just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for two and a half.
I cannot believe what the fuck is happening. What the attorney for Karen Reed is telling the court is that they went to the DA's office to get all the shit off from Proctor's personal phone. Remember, this is the added information from Proctor's personal phone because they got Proctor's work phone. Well, the feds got Proctor's work phone. And then they went through motions for like months and months and months and months to get Proctor's personal phone. And then the DA's office was told in the criminal context with the other cases, Miles King and the other cases, they were told, well, there's probably not going to be much there anyway because he had gotten a new phone. And then they were able to get to the iCloud. And remember, the iCloud dump was discovered, and the next motherfucking day, Proctor withdrew his appeal of losing his job. The next day. And now what we are being told is that Karen Reed's attorney went to the DA's office and said, hey, we're gonna need all the stuff that you got off of Proctor's phone / iCloud. And the DA's office went, that's Proctor's phone, go get it from Proctor. And so they went to Proctor. And do you know what Proctor said about the new phone that you weren't gonna get anything off of? Lost my phone. You didn't just lose your fucking phone. Miss me. I do not believe you. I do not believe you for a single solitary second that this was a whoops, the phone is lost. Karen Reed sued him personally in the civil case in federal court, which this is going to have to come up there too. And he's a necessary witness here. So he would have gotten a notice to preserve ages ago. So now you're in full don't delete your shit mode with spoliation of evidence. At least there's a remedy for it, that the DA's office is going to have to turn it over. But do we trust that the DA's office will do the right thing? The spoliation of evidence is a civil sanction. It is a monetary sanction, and there can be other jury instructions, but it's not something that they can go and arrest him for. It's civil sanctions. And he's like, whatever, come after me for the money.
Well, let me ask a question first. Attorney Diller, have you spoken with Attorney Rosenberg on the issue?
Yes.
Okay. All right. Go ahead, Attorney Rosenberg.
So first of all, there's no motion to compel before you, Your Honor. And Attorney Diller is asking you to, quote, provide guidance. It's not guidance. What he's asking you to do is change what Rule 26 says about what, and Rule 34 says about what we have to do. Well, here's exactly what happened. Plaintiffs.
There isn't a motion to compel. So Rosenberg is like, no, let me explain.
Serve document. Well, this
Hang on, Attorney Rosenberg. Excuse me for cutting you off, but there's no motion. I don't want to have to hear these types of issues without the parties having spoken. All right? So
I agree.
What are you supposed to do under the rules? And if you need to come to court, that's what we're here for.
Understood.
But
Understood, Your Honor.
please communicate with each other.
And Rosenberg's like, no, we will follow what we're required to do in the rules and not anything else. But I imagine that Diller is not indexing things for them, so they're not going to index things for him. If everybody worked well together, then everybody would be able to do it. But if that's not the way they have it stored, they don't have to do extra work to turn it over. So we've talked to your e-discovery people. Your e-discovery people can index it. We've been working with them. As we covered the discovery conferences with the court and all the lawyers in the wrongful death case brought by the O'Keeffes against Karen Reed, the Waterfall, CF McCarthy's, we see that there are discovery issues that are kind of boiling over. We have seen Karen Reed's attorney Rosenberg saying, Your Honor, this is the circle that we are stuck in. We send a subpoena, we get ignored. We reach out, we try to meet and confer, we get objections. We ask for things, they tell us that things don't exist, then we find out things do exist. And we are stuck in this pattern of not getting the discovery that we need, not getting responses to our subpoenas. And then we did see a couple motions to compel. We actually saw a motion to compel regarding Sergeant Good. But then in that hearing on February 3rd, Karen Reed's attorney Rosenberg drops the, oh, by the way, we went to the district attorney's office to try to get all that Proctor discovery from the personal phone that didn't exist. And then, oopsies, there's an iCloud account, that discovery. And the DA's office said, no, you need to go get it from Proctor. So then Karen Reed's attorneys went to go get it from Proctor. And Proctor's like, so that phone got lost? So now Karen Reed's attorney is going back to the district attorney's office being like, okay, you told us to go get it from Proctor. And Proctor's like, oopsie-doodle, I don't have it. I lost my phone. So Proctor's phone is lost, and Now they are trying to set depositions with all the parties, the O'Keefe parties, Karen Reed, and the two bars. With all the parties, they have 41 depositions they want to take. The attorneys aren't going to take the deposition until they have the discovery. And so the judge is like, can we get all the document discovery done so that we can get to the depositions? Because we have a deposition cutoff in August. How are you going to get 41 depositions done with at least 5 attorneys plus the witness? How are you going to get these 41 depositions done? So the court is now narrowing down on the attorneys and is like, look, I don't want to have a meeting to have a meeting, but if that's the way things are going to get done, then we're going to do it. And so the court has set subsequent meetings to try to keep this moving along. Memorandum of law in support of defendant Karen Reed's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication. Defendant Karen Reed respectfully requests the court order plaintiff's counsel, Diller, to destroy all copies of an email that Reed inadvertently sent to plaintiff's counsel on December 16th. Reed accidentally replied all to an email on which she was BCC'd, blind copied, which unintentionally included plaintiff's counsel on her otherwise privileged message. The reply all email directly related to Reed's legal representation and this case. Despite numerous requests that began 39 minutes after the reply all email was accidentally sent, plaintiff's counsel refuses to delete the email, temporarily sequester the message, or even seek the court's instructions. Therefore, Reed seeks an order requiring plaintiff's counsel to delete the message and any copies and recover and ensure deletion of any copies sent to his clients or anyone else. Look, don't BCC. However, it happens that things are inadvertently sent. Most lawyers have grace in this because it happens. Most of the time, lawyers will say, this clearly wasn't intended for me. We saw that it wasn't intended for us. We have not read it. It seems that Diller is taking the other tactic with, nah, you sent it to me, fuck you. Which is generally not how this works. So when we see the lawyers, this motion was filed February 4th. We have just watched hearings from February 5th and February 12th. I'm wondering if this plays into the lawyers not being happy with one another. Plaintiffs O'Keefe et al. Submit this memorandum of law in opposition to Karen Reed's motion to order them to destroy the email. Defendant Reed has presented no valid basis to claim impropriety on the part of plaintiff's counsel with respect to the contested email communication. Reed possesses the burden of proving that the email communication in question is protected by attorney-client privilege, and that such privilege was properly preserved. Plaintiffs contend that any applicable privilege was relinquished when Miss Reed responded to opposing counsel, because Reed and her team failed to adequately mitigate the clear and avoidable risk of inadvertently disclosing confidential communications. In addition, they say even if privilege is deemed to apply, plaintiffs are entitled to retain and utilize the email communication for impeachment purposes should Reed provide testimony inconsistent with her prior statements. Relevant background: during a status conference on November 21st, the parties convened pursuant to Rule 9C at the direction of the court regarding plaintiff's contention that defendant Reed failed to provide a proper response to plaintiff's interrogatory number 1, seeking the factual basis supporting Reed's third-party culprit defense as required under the rules of discovery. Okay, interesting background. During the status conference, the court said, have a meet and confer conference. Y'all talk amongst yourselves. The court's not going to solve this. If you think Reed didn't answer the interrogatory, y'all sort it out. On December 15th, plaintiffs filed a motion to compel further answers to interrogatories from defendant Reed, together with Reed's opposition and plaintiff's reply. The same day, plaintiff's counsel served Reed's team of attorneys via email with the motion to compel 9A filings, including plaintiff's reply brief. The following day, Reed's counsel responded to plaintiff's email denying the allegations in plaintiff's reply brief and seeking immediate clarification regarding the statement that, quote, Reed and her team not only have leaked evidence that now appears inconsistent with the under oath answer cited by Ms. Reed, but have also stated publicly that she has evidence to suggest John O'Keefe was killed inside the house, Exhibit 1. Unbeknownst to plaintiffs, Reed's counsel apparently BCC'd Reed to the subject email chain before sending the response. All right, let's see if it's in Exhibit 1. Let's go to the email. Mark, in your reply brief filed with the court, you state, quote, in doing so, Reed and her team not only have leaked evidence that now appears inconsistent with the under oath answer signed by Miss Reed, but also have stated publicly that she has evidence to suggest John O'Keefe was killed inside the house. They have stated that. I don't know about the leaks, but they have stated that they have evidence to suggest he was killed inside the house. They do. We deny leaked evidence. Please identify your Rule 11 basis for making this claim, as we think this needs to be cleared up immediately. Okay, that's the email. That's the context. Reed's team is like, what are you talking about? And what are you alleging that she said publicly that's inconsistent with her signed answer to interrogatory? The following day, December 16th, Reed's counsel responded to plaintiff's email denying the allegations. Reed was BCC'd. Approximately 46 minutes later, Reed replied to all email participants with factual allegations that are relevant to the aforementioned motion to compel filings and the subject matter of the email chain. The sworn answers are, they say, inconsistent with what she emailed, which would be a real big deal. However, I don't know if I trust anyone to accurately represent what's happening here. The precautions taken by Reed and her team to ensure confidentiality of communications were careless, not reasonable. In all likelihood, by her own direction and or by recommendation of counsel, Reed has been BCC'd on all email communications with opposing counsel since the outset of this lawsuit. You can't know that. That is pure speculation. This court should find that Reed waived any privilege with respect to the subject matter of the December 16th email. They go on to argue that here, Reed's choice to respond to the entire email chain and to make factual assertions directly relevant to disputed issues in this case, whether inadvertent or not, is a bell that cannot be unrung. The plaintiff should be permitted to retain Reed's entire email and use at trial and further depose Reed concerning the purpose and meaning of the subject email communications with any conditions the court deemed necessary. So they want the court to say it's not privileged, and if the court says it's privileged, then they want the court to say you can use it for impeachment even if it's privileged. So, with all of this background, yesterday there was a hearing regarding the email.
This is, by Attorney Diller, an opportunity which is evidenced in his opposition to our motion, Your Honor, where he actually goes so far as to make a sweeping allegation that he says that Ms. Reed and her team, in all likelihood, by her direction and or recommendation of counsel, has been blind copied on all email communications with opposing counsel since the outset of the lawsuit.
I think Karen Reed wants to know everything that's going on in the case. Sure, fair. There's a lot of ways attorneys can keep their client in the loop without a BCC. I think that assuming, because Karen Reed has said that she has been incredibly involved in her cases, you can't assume that that means she's been BCC'd on every email, or this probably would have happened sooner.
That is an outrageously inaccurate statement. It doesn't even comply with Rule 11, where a lawyer signs his name to pleadings and certifies that he has a good faith basis to make such a claim. What that means is Mr. Diller is trying to take facts that don't exist, create this narrative of recklessness, which does not exist. Ms. Reed was blind copied once, replied all once. You should rule that there was no waiver of the attorney-client privilege here. This was not a voluntary waiver. This was an inadvertent disclosure. Regarding the impeachment value of this email, we'll provide you the email in camera as you have ordered, and you will see that it squarely fits with everything Ms. Reed has answered in the second interrogatory that was posed to her. So it has no impeachment value. The plaintiff's attorney was asked to return it. There's plenty of discussion in the rules of professional responsibility in the case law about returning an email that's been inadvertently disclosed. This should just end today. Mr. Diller should not be permitted to use it. He should not be permitted to disseminate it, and it should be destroyed.
The law's privilege is waived when its contents become public. Counsel, to the extent that there may have been a privileged communication when the email, to which I did not disseminate, chose to put its contents directly into a public filing and attach the answer to interrogatory to which Attorney Seligson just communicated to you, stands for the same issues and the same facts are live. But I didn't understand why there was no attempt by counsel to seek an in-seal filing of this together with the answer to interrogatory and or an in-camera on all of it. I identified that there were inconsistent statements in the email that was provided to me before anybody tried to recall it or advise me that that was intended as a client confidential communication. I then said, I'm not intending to disseminate it, but I do believe in arguments made that she's waived it. And I more so think it's significant that should she give inconsistent testimony moving forward, it certainly has impeachment value. I believe that they have waived the any privilege that may have existed in the communication by publicly disseminating the contents of it. And then secondarily, I have every right to use it for impeachment purposes as we move forward in this litigation.
What we saw in the arguments over Karen Reed's email was the attorney for plaintiffs, the O'Keeffes, saying, look, Your Honor, first, it's not privileged. This isn't inadvertent. They weren't being careful. We should be able to use it for impeachment. But Karen Reed's attorneys filed a reply with her answer to the interrogatory, not under seal. So it's now all out in the public. So they've waived the privilege by putting the subject matter of the privileged communication out into the public. To which Karen Reed's civil attorney Seligson responded, bro, what? That's just my summary, saying this was an inadvertent error. It does not waive privilege, and it should not be used for impeachment. And the court might split this issue. The court might split the issue and say it is a privileged communication. However, to the extent it differs from anything else Karen Reed said, it might become something that can be used for impeachment down the road. But the court has not evaluated the email. He said that at the beginning of the hearing and indicated at the beginning of the hearing that he wanted to hear their arguments on what the law was in this area before he looked at the email and decided. So the court took it under advisement. The court will issue a written ruling at some point in the future. We don't have that yet. We've only time traveled as much as we can. We've run out of room to time travel. But it's really hard to put the shit back in the horse and unring that bell. If the court finds that the areas are the same, the court might say, you know what? You can use the interrogatory. You can't use the email. They're same. You can't use it for impeachment. Delete the email. Or the court might say, sure, you can use the email for impeachment. However, it's same as the interrogatory. So what would be the purpose? So we'll see. There was a motion filed yesterday that I grabbed off of social media in one of the criminal cases relating back to the Proctor problems. Karen Reed's attorneys are filing in the criminal cases about Proctor's phone. Response in support of Commonwealth's motion to provide, pursuant to a civil subpoena, information derived from former state police trooper Proctor's personal phone previously obtained through court order. Michael Proctor lacks standing to object to the Commonwealth's agreement to produce documents currently in its possession, Commonwealth, in response to a civil subpoena, despite his desire to hide his apparently appalling conversations with fellow law enforcement officers and others. So Proctor's objecting, and the Reed team is objecting to Proctor objecting. None of this would be happening if Proctor hadn't lost his phone Despite his desire to hide his apparently appalling conversations with fellow law enforcement officers and others, which he clearly assumed would remain permanently shrouded in the secrecy of his group chats. And so they are citing case law saying Proctor does not have standing to say to the DA, do not give them that information. This is between the district attorney's office, Reed's attorneys, and all these defense attorneys. Stay out of it, Proctor. As the court knows, based on its prior orders concerning these documents, Reed's counsel has told Proctor's counsel many times, and as the Commonwealth's motion confirms, neither Reed nor the O'Keefes have ever received these messages. They are completely separate from the text messages Reed's criminal defense team and the Commonwealth received during the criminal trials. Right, because those were from the feds.
The FBI!
From a different phone. This is a different group of information. Finally, Proctor makes two cynical and meritless arguments. First, he writes in his opposition that, quote, if the Reed attorneys want discovery from Proctor, then serving a request for production of documents on Proctor in the unrelated federal matter constitutes the proper vehicle in which to obtain such discovery, rather than having this criminal court amend its protective orders. That's not how that works, Proctor lawyer. That's not how that works. They're not the same set. They're not the same discovery. They go on to say this disingenuous argument ignores the fact that the same counsel that filed Proctor's opposition has informed Reed's counsel that in the short period of time when the Commonwealth returned his phone in question to Proctor and when Proctor engaged his current counsel, Proctor lost the phone and no longer has access to it. Therefore, as Proctor well knows, the O'Keefes and Reed can only obtain the potentially relevant documents from the Commonwealth. And Proctor should not be permitted to blatantly rely on his own spoliation of evidence to keep his biased and offensive speech shrouded in secrecy. Second, Proctor attempts to grotesquely leverage the fact that his own messages on his own phone contain explicit images of women that did not consent and are unaware of their photographs being shared. After apparently violating their constitutional and legal rights by privately obtaining, keeping, and using these images for his own and his friends' personal predilections, that's strong. Proctor attempts to nobly set forth in his opposition his abiding concern about these women's privacy rights. Dude, bro, that ship has fucking sailed. Proctor should not be permitted to rely on his own inappropriate and potentially illegal act of sharing other people's intimate photographs to prevent discovery of that very act, among others. Nor should he be allowed to hide his bad acts based on his apparent newfound respect for third parties' expectation of privacy. Proctor is objecting to the Commonwealth turning over the discovery they have from the lost phone to Karen Reed and the O'Keefes. That discovery fight is being had in the context of the criminal cases where this was all unearthed. The things that are so interconnected about this is unusual because the defense in Karen Reed's civil case is but investigation. I am not responsible for John O'Keefe's death, therefore I am not responsible for all of this, but investigation. When we see motions from different things, they are all connected back to trying to get the additional discovery from Proctor's phone that the Commonwealth has in its possession, not the discovery that was turned over in the criminal case. Yes, there are protective orders for all of this. We are waiting for the court to, in the civil case, decide what's going to happen with the Karen Reed oopsie email. Don't reply to all. And we are going to wait to see what the court does with the Proctor problems from the lost phone. Those are the two things I am keeping an eye on as the civil case moves forward and as the fallout from Proctor continues in 4 other criminal cases. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.